A brief summary of State Question 794. You'll be voting November 6th, I hope. Please turn out and vote. But this question will be one of 5, and it's pretty much boiled down to these statements from the ballot title, which are it would increase the number of court proceedings at which victims have the right to be heard. It would add a right to reasonable protection for victims. It would add a right to proceedings free from unusual delay, a right to talk to prosecutors, allow victims to refuse interview requests from defendants' lawyers without a subpoena, and it would grant victims and those directly harmed by crime these rights. So they extend beyond just the victims themselves. It would apply to both adult and juvenile proceedings, and you have to check your facts carefully on these state questions, but I think there's no, it would apply to any crime. It doesn't define which crime it is, so I assume it could be property crimes as well. So I'd like to open it up to talk with Mr. Hermanson. If you could just sum it up in just a minute or two, why do you support State Question 794?
Well, myself and the whole District Attorney's Council support this because we feel that the victims' rights, constitutional rights that are already in place, need to be changed. And what this does, it changes some of those, eliminates some, and adds additional protections so that victims of crime can have an ability to be in the courtroom, to see the proceedings at each level that it occurs, be a voice at times of sentencing and parole, or any type of release discussions, that they can have an opportunity to have conversations with the prosecutor and let their views be known. Many times they may have things available to them that the prosecutor may not be available to them or know that's there. Plus, they just should be involved in that process. They are the victims. They are the people that are not remembered. I remember former Attorney General Mike Turpin used to always say that he'd go to crime scenes and see people stepping over the victims in order to read the defendant their rights. Well, the victims are important. They should be protected. They should have rights that can be enforced in a court of law, and so that judges that perhaps may not agree with certain things can't take those rights away from them.
Just a quick follow-up. We already have a Bill of Rights for victims in the Oklahoma Constitution, passed in 1996. We have state laws on victims' rights. We have the Victim Services Program. We have compensation for victims. Nationally, there is a Victim Witness and Protection Act, a Victims of Crimes Act, a Violence Against Women Act, and a Crime Victims' Rights Act from 2004. So some of those questioning this state question ask, is all of this just overkill?
Well, no. First of all, nowhere do they have the right to enforce the, quote, rights that they supposedly have. They don't have a right to take action and enforce those rights. This will allow those rights to be enforced. It also expands when they can be heard and how they can be heard. No bill cannot be made better. No constitutional provision cannot be made better. This will make it a better constitutional right for them, a right that cannot be taken away.
Ms. Legler, I'd like to ask you also if you could just kind of sum up for us why you have concerns or why you oppose State Question 794.
Thank you. I would like to thank Oklahoma Watch for the invitation to come and talk with you tonight. So I was invited to talk about the criminal defense point of view on Marsy's law, sometimes not the most popular point of view. I would just start to say that the constitutional rights for the accused exist to limit the state's power against individuals when the state seeks to deprive them of life, liberty, and property. The accused have constitutional rights because getting it wrong means that we put innocent people in prison and we let the offenders run loose. Now, victims' rights serve a completely different purpose aimed at ensuring recovery for individuals, not protection against state power, which is what we want for the defendant, whoever has been charged with a crime. Granting victims constitutional rights equal to the accused in a criminal proceeding inappropriately undermines the due process by creating conflict between the victim and the defendant's rights. It's, in our opinion, it intercedes into the adversarial process. I mean, it is meant to be between the state and the defense, those two, without an interceding party to be judged by the judge. I think contrary to what many people think, I mean, criminal defense attorneys are not against victims, they're not against victims' rights, but we are concerned about some of the pending things that are in the state question. I think primarily we're concerned with that the things that are in there will slow down the process. It's already very slow as it is in the criminal justice system. It'll gum things up more, and we're worried about the costs that will be coming with the charges with the state question, and finally with the constitutionality of the state question. Now, I mean, that there probably will be challenges, and those are other challenges and costs that the state will have to bear to fight any kind of challenges. I do wonder, though, I think that part of what Mr. Hermanson said was that this will ensure the rights. While it may enshrine them in the Constitution, we feel that it's toothless, because there's nothing there to then ensure that these rights are enforced. They're simply there, stated. They're restated from what things are already in the statute. We, as you alluded to, there are many rights already enshrined in the state statutes. And just doing a quick look today, I pulled up 5 statutes that cover rights for the victims, and we can get into that more later, but in particular, one is the duty of the district attorney to inform victims and the witnesses of their rights. And as the district attorney, there are over 17 things that your offices are supposed to ensure happen for the victims. That's already statute, it's already there.
Well, let me just follow that. Despite all of the statutes and federal laws passed for victims, you still hear from victims who say they are treated with disrespect or a lack of dignity or just lack of information in the criminal justice process. So why not enshrine it in the Constitution to force the justice system to be more proactive with victims?
Is that to me?
That's for you.
Yeah. I do think that victims should be apprised of the process, but I don't think it needs to be in the Constitution. The Constitution is supposed to be there to set out rights, not to prohibit them. And now this is a little bit different because it would be possibly setting out rights for victims and their family members. But it also, the way that it's written is toothless. There is no remedy if a victim is not informed by the district attorney's office or by the court for any process. It's simply, I don't know what happens. It's already here. All the things that they should be reimbursed and notified and things like that. And why do we need to duplicate it and then run the risk of things crossing over and making it more confusing, muddying the water?
Mr. Hermanson, the question that always comes up about Marsy's law is costs. And as you probably know, there are other states. We have at least 6 other states with a form of Marsy's law, and more voting on it in November. But there have been some who have backtracked, in South Dakota, I believe, for example, saying that this has put created a financial burden for a lot of court systems, as they feel like they have to hire people, spend a lot of more money to notify victims when crimes occur. What's your response to that? Is this going to cost the state of Oklahoma and the district attorney's offices more money?
Well, I don't believe so, and let me tell you why. The list of things she read off a second ago, what the prosecutor's offices are supposed to be doing. We're doing some of that right now. If they're not doing it, it should be enforced. The Constitution, putting this in the Constitution, would allow it to be enforced. Most of the things that they're complaining about should be happening in some way or another. She says that we don't have any right to enforce, but specifically in the language, it gives victims the right to enforce their rights under Marsy's law. And by that, it doesn't say how they enforce it, correct. But you don't have to say how. If it says there you can enforce your rights, the prosecutor should be able to file motions with the court to make sure the rights are enforced in court and that they have those rights that are appropriate. I would challenge her to show me how this interferes with the process. What right the defendant has is taken away by Marsy's law. It doesn't interfere with his right to presumption of innocence. It doesn't interfere with his right to trial. It doesn't interfere to the burden that the state has to prove beyond a reasonable doubt. The defendant still has every right enforced him before. There's nothing in here that takes away from that or is going to cause an unfair trial. And as to her suggestion that it will slow down the process, indeed, one of the things in Marsy's law is that they should be able to move the process along faster. I would suggest that every victim that's involved thinks the system goes way too slow and should be sped up. And as a prosecutor, I can tell you that things are going slow enough right now, and they should be sped up significantly.
Ms. Legler, what's your response, at least regarding the rights of defendants versus victims? It's often suggested by Marsy's law proponents that there is this imbalance, that the rights of victims should be equal with those of the defendants. Is there an imbalance? Do you agree?
I don't know that I can really speak to that. I mean, I think that it will affect defendants as far as when it comes to bond and whether that is denied or granted, whether if a family member has to be given notice under as it's written out, and what happens if notice can't be given? What happens if notice, and these are all hypotheticals because of course this is hypothetical, it's not a reality yet, but if we have to delay a bond hearing because we have to give notification to everyone, and not everyone can make it on that date, there is going to be a delay. And that's just one example. I mean, and as far as if a victim has a right or a victim's family member has a right to say when and how a trial should proceed, that's not contemplated by the Constitution or our statutes. That's for the courts, for the docket, and for the attorneys to decide when and how that's going to proceed.
Do you have a response to that?
Several. First of all, I don't see anything in Marsy's law that says they determine how the case proceeds. As prosecutor, I decide how the case proceeds. Sure. I make those decisions on a daily basis. They will talk to me. They will tell me their opinions. But one of the first things I will tell them is I'll certainly listen to what you have to say, but I will make the determinations of how the case goes forward. As far as them slowing down perhaps a bond hearing because we have to give notice to a victim, many times the judge will call me and say, you need to come down to my office in 5 minutes, we're going to have a bond hearing on such and such a case. I would love to have a delay of a day or two so I could get a victim there so that I can have time to prepare for that bond hearing, so I can hear from them why it's dangerous for this person to be released, and to have them in the courtroom. That shouldn't affect a judge. Judges are certainly stout enough to deal with having people in his courtroom when these issues are going on. But why would it be bad for victims to be present when a release of someone who's caused them harm is at issue? I think it's very important for them to have that right.
No, I think you misunderstand what I've said. I am not saying that a victim or a victim's family member should not be in the courtroom. I'm saying that part of this law is that they have to be notified. And so how do you explain, first of all, the language for who a family member is or who a victim is very vague. So who does that entail? Who do you envision that will entail having to notify for proceedings? And then once you notify all of those family members, then we're talking about transportation costs, we're talking about notice, and there is a potential for delay.
Well, this law covers so much ground. But let's just jump to that question. It does seem to broaden the definition of a victim. I think it says that those harmed directly by the crime. So, who might that be, Mr. Hermanson? Who's that going to extend to?
Well, I mean, let's take the case of something like a murder. Usually it's a family member. Usually it's a spouse and children, perhaps parents. It's usually situations like that. It's not hard to determine. You usually determine very quickly who the victims are. We send out a letter almost immediately to who we perceive to be the victims. Sometimes that group grows, sometimes it shrinks, but we will learn that from the victims' families who else should be informed. It shouldn't delay the process. What is wrong with the people that are harmed by the criminal act of someone, of them being informed? How does that cause the system of justice to be derailed? It doesn't. It merely is doing what we all should have been doing all along, and that is making sure those harmed have a right to be present in the courtroom and have a right to at least have the ear of the prosecutor in talking to them about that process.
Well, let me ask both of you. Who has the responsibility now? You say that that putting this in the Constitution will force people to remedy the issue. But whose responsibility is it now? Is it the district attorneys? Is that not being done by current district attorneys around the state and notifying the victims and going through these other processes to involve them? What's your take on that?
Every district in the state of Oklahoma has a victim witness coordinator. A victim witness coordinator is responsible for getting witnesses to court, keeping in touch with the victims. Many of the districts in the state have what's called a victim advocate on their staff, one or more. That victim advocate usually stays in touch with each of the victims, answers their questions, makes sure they're notified of any type of proceeding, tries to make sure they're present at any proceeding that's going forward. In my office, most of the things in Marsy's law is happening already because I just choose to do it. It's not happening that way across the state. I will have to do it in the future with it being a constitutional requirement, and I welcome that. I mean, I welcome that. I think that should be, because the next DA may have a different policy than I do. Circumstances may be different. They should have a right. And I've also been in the courtroom where I've told the judge, these victims have certain rights, and the judge has determined that doesn't matter. Well, he can't do that when it's a constitutional requirement. And we can't do that where we can file motions and writ them up to appellate court to enforce the rights of the victims. And we'll be able to do that under this provisions.
Do you have a response to, what's your perception of how victims, how involved they are now, Ms. Legler?
I do think the onus is on the district attorney's office, and your office may be an exception, it sounds like it, but there are 77 counties around the state, and I don't believe that they are enforcing that. And that's, I think, one of the contentions we have is there are already numerous statutes covering all of these things that should be done. So why do we need to enshrine it in the Constitution when the Constitution does not? There is nothing that I can see from the proposal that says there will be any kind of remedy for, if this doesn't happen.
It says enforce the rights enumerated in this section. It says directly in Marsy's law. And you've made my point for me, because if there's other district attorneys are not doing what the law requires, it should be a constitutional right that's protected and that they can enforce it.
Do you think district attorneys will have to spend more money to enact these provisions?
There'll be more postage for mailing out notices, minimal at best. There'll be more phone calls, but again, staff people should be able to handle that. Every district attorney, the whole district attorney's council voted to support this. So the DAs are not afraid of these provisions or the costs that may be associated with them. Not at all. I don't think it's going to be much of an increase at all, because, as counsel said, we should be doing it already.
What about with notification now? Do you are victims notified of proceedings? I mean, that's part of I think what passed in 1996 to provide notification of some proceedings. We
try. I mean, we try to do the best we can. It's not perfect. Obviously, with the constitutional amendment, it will put us on higher care to make sure we do better. We have letters that we inform them of when the next hearing is and what's going to happen at the next hearing. I think perhaps victims will feel more empowered to be able to come to some of the proceedings that they're not coming to now, if they know they have a right to be there. Because sometimes, victims sometimes are not forceful in pushing their way in. But if they know, and again, this debate and this whole state question will do a great job of informing victims of crime that they do have rights to come forward. And I'd hate to see that new empowerment that they may have be somehow squashed by a loss in this election.
Mr. Legler, of course, defense attorneys have a job to do, which is to defend their clients and give them, that's part of the justice system. But some critics would say the defense lawyers are simply looking for a way to mute victims' voices in the process. What's your response to that?
I'm sure there are defense attorneys who would like to do that. I mean, I don't think that's the overall goal. I mean, our goal is to defend our client to the best of our abilities. I mean, the things that I see the most where victims have a say and they have an impact is the victim impact statements, where they are allowed to write a statement and read it into the record, and that could be at sentencing, that can be to the jury, depending on what kind of proceeding it is. I think that's very powerful there, and I just simply don't see where, if your offices are charged with notification and other things like that, we have victim impact statements that are already allowed. Victims are allowed to and are supposed to be notified for parole hearings. These things are already all in the statutes. They are all there. What is the need for a constitutional amendment other than your argument is that it will enshrine it and it will make district attorney's office do what they should already be doing? That doesn't make a lot of sense to me. Why do they need a constitutional amendment for them to do their jobs, which is already enshrined in the statutes?
Well, they're trying to do their job. And again, I took for what you said at face value that there are DA's offices that aren't
Oh, I
doing
have no
this.
idea. I can't speak for the district attorney's offices.
You made the comment earlier that they weren't doing it, so I took
No.
your word at that. I would assume that they all are doing that, because I know my office does. Those people that I'm close to have been doing this. But if there's a failure, if a judge will not let a victim impact statement be read, if they decide that they want to edit it in some way, which statute says you can't do, if there are things that happen that are inappropriate, there needs to be a remedy. There needs to be a stand that they have. I've not yet heard anything negative about having a constitutional amendment versus a statute. I've failed to hear anything that says that. And clearly, none of it affects the defendant's right to a fair trial. Most of the rights that the victim has is to be in the audience, or to do things at sentencing, or to know whether this person is being released from jail or prison. Those are most of the rights that are involved in this, along with others. But they do not affect the finding of guilt or innocence, and so the defendant is still completely protected on those rights.
Ms. Legler, do you think that this measure would and somehow upend the presumption of innocence in the process?
I think depending on what the input could be, then it possibly could. I mean, that's harder to say because, as you correctly state, that's not that they can have an impact at the jury trial itself, but when you're talking about things happening before the trial, as far as publicity, pretrial publicity, things definitely at sentencing. Now, that's not the presumption of innocence, but it does affect the defendants as far as what sentence they get. So I do think that there could be a negative impact on defendants.
I mean, a lot of the rights being discussed here or in this proposal have to do before the defendant is ever convicted, correct?
Correct.
Only as regards being in the courtroom, knowing if he's been released. It doesn't say anything about pretrial publicity. It doesn't say anything about what a victim can do just as a citizen of the state of Oklahoma. Everything in there is to provide them an access to court, an access to perceive. I mean, if you lost a loved one, would you not want to be there and hear what's being said and see what's being said? Would you want someone to subpoena you and try to use the rule of sequestration to keep you out of the courtroom? Again, it'd be wrong. It'd be violation of rules, but things happen. And a judge could try to make a ruling that he thinks is fair, but we need to have that constitutional muster to say no.
Now, at least in one other state, there was an instance, I can't remember which state, an instance in which a victim's appearance in court led a judge to throw out a plea agreement. Do you think that's going to happen, and is that something that's desirable?
Who are you asking me?
Either one.
Okay, I can tell you that happens. I can tell you that during victim impact statements, judges sometimes will not accept a recommendation that the judge feels is inappropriate. But you know what? If the judge finds that inappropriate, who is the one person in the courtroom that's completely unbiased because he's heard from the victim, don't you think that victim's statement was necessary to hear? Don't you think that perhaps the people the prosecutor and the defense attorney need to either file another way out or to take it to trial? What is wrong with victims having a say, and the judge, if he finds their merit to it, making that type of ruling?
Ms. Legler, do you find any problem with that that sort of thing in the process, if it were to happen? Is that?
Of course. I mean, that's some of the issue I have. I mean, that right is already there to have a victim impact statement and for victims or victim family members to speak and to give their opinion. So, I mean, I hate to keep beating a dead horse, but I don't understand why we have to duplicate things that are already there. And it goes to your argument is that they would have the constitutional muster behind them, but could you explain to me what you think the remedy would be in the middle of a trial if something were to, if you felt like that a victim wasn't able to say or do something, what you would do in the middle of a trial as a remedy under this proposal.
I would request emergency writ to the court, seek action to force the judge to abide by what the Constitution requires him to do.
And how often is an emergency writ granted in the middle of a trial?
Not often, but if they do, they're certainly not going to do it for a violation of a statute. They may do it for a violation of a constitutional right. Again, stranger things have happened.
Sure, but I would disagree with your proposition that you could, in the middle of a trial, do an emergency writ and get any kind of traction. I don't believe that would happen very often, if at all.
I'd like to open this up to the audience. If you have questions, just raise your hand, and we'll very quickly have someone with a microphone that will come to you, and you can ask both the guests or either guest. There's a first hand to go up there.
Hi.
Hi.
I had a question. You were discussing bond hearings, and you were saying that you might be told by a judge that in 5 minutes there's a bond hearing, and you were saying that you think it's a good thing to have a day or two more. Well, a day or two more for a bond hearing means that that person is in jail for a day or two more. Do you not see any issue with leaving someone in jail for a day or two more when, I can understand maybe feeling that's okay if it's a murder charge, even though at that point they're not convicted, so there's some issues with that. But if they're in jail on a property crime and you're going to wait a day or two more, that's a day or two more in jail, and I would not like to spend a day or two more in the Oklahoma County Jail. So,
let me explain the process to you. First of all, before a person's arrested, bond has been set. Or if they're arrested at the scene of the crime, bond is set within 72 hours. So bond is set before we go have a bond hearing. The bond hearing is to reduce the bond to another level. Well, they're sitting in jail with the right to post bond when that request comes in. So the fact that there's another couple days doesn't mean they still can't bond out at the current level. But what is wrong with having a fair hearing where people are present and you can be prepared to make an argument and present evidence for that? Usually, the defendant has hired a lawyer or lawyers have been appointed. Wait of a couple days for people to be present that have an interest in the case. I don't see anything wrong with that because bond has been set.
but if the bond hearing is to lower it and they can't afford a higher bond, they could have afforded a lower one, you're still leaving them in jail.
I mean, I hear what you're saying. Again, a short delay to reduce or increase bond, I don't think is a detrimental effect on the defendant, even though he may have spent another couple days in jail.
This gentleman had a question.
Yes, I hear you using defendant and victim interchangeably, and that kind of confuses me.
I'm sorry.
Because not say you get arrested, you're not usually a victim.
Correct. When I used to use the word victim, I'm talking about the person who has been harmed by the criminal act of another person, and the defendant is the person that's charged with the crime.
Mm-hmm. Okay. Well,
If I misspoke, I apologize.
okay. Another question. Here in front.
My question has to do with specific victim of rape or sexual assault. Currently, my understanding is that the victim basically can't bring up the defendant's or the accused past history, where these type of situations have occurred before. They're in the dockets. They're showing there that there were protective orders and violations of protective orders. And the victim can't go back into their past and bring that stuff up, but the defendant can go back into the victim's life and bring up anything they want to the day they were born. I mean, am I wrong in that? Is that?
You are a little wrong.
Okay, could you explain it to me, please?
There is ability to show propensity in rape cases. If there's a history and a propensity to commit this type of crime, with a proper notice and a proper showing to the court can allow propensity evidence to be presented. Likewise, there's rape shield laws that should protect in some circumstances, victims of rape. Whether or not it will work in all circumstances will depend, again, on the judge's rulings. Really nothing to do with Marsy's law, but
Can the case be reopened?
again, it's going to depend on the case.
Marcy's law passes?
I don't believe
I
there's
don't-
any kind of retroactivity applied to it.
I doubt
I don't believe there's any kind of retroactivity applied to it. Usually it will specifically say if it's supposed to go back, and anything that prior to it being passed.
Thank you, that helps a lot.
The gentleman in the back had a question.
So if it becomes a constitutional law, there is a requirement more for the DAs to adhere to, really to talk to the victims more, to be more informed, correct? And then if they don't, is there any sort of punishment to them?
There's not a cause of action against the prosecutor or against the judge. There's a right to enforce your rights, but there's not a cause of action to file a civil lawsuit or anything like that, but a right to enforce your rights through the courts.
Question here.
Yes, my question is, if we already have these statutes online, why do we have to have a constitutional amendment? Why do you, as a district attorney, feel that we need to have more rules that are already on the books?
Well, there's a difference between a statute and a constitutional requirement. The constitutional requirement has, first of all, the legislature can't take away those rights by passing another law. Secondly, with the enforcement provisions that are in Marsy's law, they can be enforced upon if, let's say, the prosecutor's not doing something you want to, he won't do it, you can file a motion with the court seeking to enforce your rights to that regard, or if the court's not allowing you to do something, file a motion to that effect. It will allow victims to have be empowered, if you will, and that may not be a word you like, but empowered means that they know that they have these rights and they cannot be taken away from them by any specific act.
Follow-up question. Does this detour or take any of the rights of the accused with the implementation of Marsy's law?
I really don't see it. They're not going to be they'll be in the courtroom, but there are rules about how you act in the courtroom already. I was involved in the Oklahoma City bombing case. We had many victims in the courtroom every day in that case. There were rules they had to follow, but they were allowed to proceed in that case. I've had cases where victims had to stay out of the courtroom for one reason or the other. Never did I feel, I felt uncomfortable having 50, 75 victims in the courtroom at one time, but the jury came back and did not give the death penalty in that case. So it did not affect them in that regard. So I would suggest that nothing in here will have a negative effect on the rights of the defendant, which are paramount and which should be protected.
I'd like to follow up a question related to that. I'll start with Ms. Legler. Both of you can answer. Oklahoma's prisons are way overcrowded. Their jails are crowded too. They're in awful condition. Everyone agrees. And if you read Marsy, some of the literature from Marsy's law proponents, they say the testimonials, which are very moving, talk about criminals who got off with light sentences because the victims didn't have their voice in the case. Or they're released on bail earlier. They didn't have a chance to come down to the parole board or whatever, although I know there are requirements for that now. So in a state that is incarcerating so many people and in which some of the top leaders and communities are trying to get people out of prison, is Marsy's law going to lead to longer sentences? The reverse is that if it passes, victims will get their voice in, more people will be sent to prison. Is that what, do you think that's?
I think that's a fair statement, and I think it's a little disingenuous to say that you don't think that victims will somehow affect the process, because judges are humans too. And if you, I know that they're to be impartial, but it can affect the sentencing, and that's what it's exactly the issue that you're talking about as far as longer sentences and longer incarceration. So yes.
Do you think that's going to happen or not?
It could happen, and let me tell you why that's not a bad thing. If the judge is given more information, and if the judge understands the facts better and determines what the appropriate punishment should be in the case, or if the jury understands the harm that these people have done and sentences them to more time because of a better understanding of the facts, that's a good thing. It's not a bad thing. If the person should spend more time because they're a dangerous society, if their person should be in jail because of the type of crimes they committed and what they've done to these victims, that's not a bad thing. Information is not a terrible thing. So, will it in some occasions have some effect on the court? It might. It might not. We had a case last week where the judge, at first, after hearing the victims' families, was considering not accepting the recommendation, but he thought about it for a day or two and then ended up following the recommendation the state made. So I don't think, not all imprisonment's bad. In fact, most imprisonment is a positive thing for our society because we're keeping people that are dangerous off the streets. And again, the discussions on getting people out of prison are dealing with victimless crimes for the most part, and these are not victimless crimes.
But this statute applies to all crimes, so it does apply from anything from theft to murder, or excuse me, the state question.
Question, if it applies to property crimes, does that mean if my home was burglarized, I have a stronger victim's voice, and I can influence that process too?
Yeah, you're a victim, yes.
Yeah.
Yes.
Okay.
Yes.
Questions?
Could I just say real quick,
Sure,
too?
go ahead.
Sorry, I had lost my train of thought. Unfortunately, I mean, the reality is that it is an imperfect system, and people are influenced in smaller counties particularly by what they think their constituents do and do not want. And so just as your example, where you have the community coming and saying something about, well, we think that he deserves 20 years, and the judge was maybe thinking 10, there will, in my opinion, be an influence because they're going to listen, the judges will listen to their constituents over a defense attorney because they want to be reelected. So I do think that there is going to be an influence on sentencing, and we are trying to get away from, I do not believe that every person needs to be out of prison. There's a reason we have the system that we do, but there are many, many people who are locked up for too long. I mean, the sentence isn't just, and what you've just proposed is going to make it even longer. And even if you don't support that victims should not be in jail for that long, we all, as a state, have to pay for it. Fiscally, it's irresponsible.
The number of times that I've been at a sentencing or at a hearing where the defendant packs the room with his friends, sends hundreds of letters sent to the judge about what a great guy he is, what a wonderful person he is, in spite of the heinous crime that they've committed. I don't see anything wrong with victims being able to be there also. I don't see any wrong with them being able to express their voice. The judge is probably under more pressure of those business leaders that saying he's a great guy than the victims that are coming in the court, and so they need to be heard.
Are there a lot of business leaders coming out and supporting defendants?
Absolutely.
I need to practice in your county.
Question here.
Hi, I am the current president of Oklahoma Homicide Survivor Support Group. So most of the crimes that I have been involved with are, murder. My great-grandmother was killed. It was a cold case. It was in a small town, and I'm actually changing my question up because you brought up the small town. In the smaller towns is where notification needs to be prevalent. Whenever we talk about the notification system, in my case, we didn't have a victim's advocate. There may have been one all along, but they weren't reaching out to our family because it was a cold case and it had been so long. So I'm reading the Daily Oklahoman, and I see my great-grandmother's case in the Daily Oklahoman that they have a suspect. But the bigger thing is that notification for just even a hearing. I had to drive over an hour to get to the courthouse. I show up to find out that the hearing had been changed, and I wasn't notified. I took off work for this, and this didn't happen just once. And I'm around so many other victims that this is common. Until the case has actually been assigned to the district attorney's office, people are trying to find out where their case is, who do they contact. So we have a system called Vine. I'm not sure if many people are familiar with this, but could you see something like this not costing as much for, because everybody's talking about the cost, but could you see something like Vine coming in to help with the notification process? Because a lot of victims probably wouldn't want items mailed to their house anyway.
Mr. Hermanson, what do you think?
But
I don't know the answer. That's not a bad idea. I don't know that we've ever discussed it. I don't know if Vine has the capabilities of doing that. For those that don't know, Vine is a system that right now is being used to tell victims where the defendant is housed, when he's been released, when there's been some change in his security clearance in prison and such as that. I think that's a good question, and I'll check into that. I don't know if Vine is capable of doing that. They would make things easier all around and be inexpensive because it would be on the internet.
Any other questions?
I have a two-part question. The first one is, from what I understand, the state question is just a notification. It's not requiring them to travel. Like, they're just saying, hey, here's what's up with happened in the case. You don't have to travel here. We're just letting you know. I don't know if that was correct. And then I was reading an article in the New Yorker about the Timothy McVeigh trial, about the judge not wanting the victims to read their victims' impact statements and watch the case proceed. And they had to. I mean, they went. They went to court over. They agreed with him, and then Congress passed a law saying, you can't do that. And then it wasn't clear they could enforce that. With this state question, is there a little bit more muster towards the victims to say, okay, I would like to watch, the case go on through closed circuit camera and read a victim's impact statement? Is it a little bit more weight to it, I guess you can say?
The victim impact statement comes after guilt is found. Usually the rule of sequestration deals with learning from another witness what they testified to, and so you have to leave usually for the guilt phase. It's usually doesn't apply to the sentencing phase. It's sentencing. There's less strict rules on the rules of evidence and such. I'd be shocked if usually victim impact statements are shared with defense attorneys prior to sentencing. Even if we can, we try to do it even before the trial starts, so that they are aware of what's going to be said. I don't see the rule of sequestration affecting your ability to read your own. In Oklahoma, if you can't read your own, you can have someone in the DA's office or some family friend read it for you. So I wouldn't think that interfere, would you?
No. I think that there's a little bit of confusion because the experience that I have seen is that most of the time, if the state will like to have a victim or the victim family member testify first, and then there's an exception. Usually, the defense. I've never seen the defense object to then that family member staying in the courtroom. And as Mr. Hermanson says, that is a right of the defendant to have. Witnesses not hear the testimony of others before they testify. So I think that already is happening where victims testify and then they're allowed to stay in the courtroom. And as he said, the second stage, that's usually, everybody's there.
There's a question up front from this woman here.
Hi. My question, I do have a two-part question as well. I want to find out if the Marsy's Law would actually enhance or help victims' rights in a divorce case, a divorce proceeding.
With domestic violence or just divorce?
As a domestic violence victim.
Okay.
I'm not sure that it directly addresses that, but there is a statute already that addresses notification for domestic violence.
Yeah, there is
victims of domestic violence.
Right now, there's requirements to law enforcement and giving certain notification to victims of domestic violence, and they are given the information about how to file a protective order, how to contact the district attorney's office, and such. As far as whether or not Marsy's Law has anything in it for directly affecting a divorce proceedings, I don't think it would. It's more dealing with the criminal type proceedings.
I'd like to ask one question, Mr. Go ahead.
No, I'm sorry. I think you had a two-part question. Is that right?
Oh, yeah, I'm sorry.
So my other question is that in my situation, when I actually called the police on my husband for domestic violence, after the fifth time of me calling the police arrested me, and I went through the whole bond and all that process, and when I was released, then I was encouraged to go make my own police report because they refused to take my own police report when they arrested me. they refused to listen to what happened to me. They had decided that the police had decided that I was the perpetrator rather than the victim. So after I was released, I went to file my police report against my husband, and they took it and they asked for his arrest, and the DA's office squashed it or refused to arrest my ex. So in that particular situation, I am a victim of domestic violence. I made the proper steps. I've tried to do what I consider, what I thought are the proper steps, going to speak to the DA's advocate, the victim's advocate, to be heard. So in my particular situation, they never filed a case against my husband. So I feel as if I have no voice, and I don't know how to enforce that. And will this actually help give me a voice to be heard, because I was shut down so many times?
Well, again, not knowing, I mean, I hear what you're saying. I don't know what the police reports say. I don't know what the officers are saying. So I'm at a little bit of a loss. If you're not identified as a victim, the question would be a question of whether or not Marsy's law would apply to you. Obviously, usually you're not considered to be a victim of your own case. And if there's not a case against your husband or ex-husband, I don't know how that would work.
It does raise that question of whether, will police be affected by Marsy's law in terms of requirements of notification, et cetera?
Law enforcement will be affected somewhat, and again, law enforcement is supporting Marsy's law, so they're not afraid of the requirements that are placed on them. It's my understanding that law enforcement has offered to, just like in domestic violence, where they give notification to victims, to expand that to all victims of crime, carry a card with them that they can give them, explaining them what their rights are under Marsy's law, so that they then can be, again, empowered and know what they can do and who to contact.
Mr. Legler, did you have thoughts on domestic violence?
Sorry, yeah, I was just, it goes back to why, I mean, the duplication of putting it into the Constitution, where, I mean, we have a statute that talks about, particularly for victims involving domestic abuse, rape, forcible sodomy, or stalking, there are already 4 things already listed in the statute that the district attorney's office is supposed to be enforcing. And I don't mean your office, I just mean the district attorney in general is supposed to be enforcing. And so these are specific things. All of these statutes list specific things, whereas Marsy's law, in my opinion, is more general. I mean, it's very vague, and the language is vague. And so we already have specific things to control these, to dictate how these are to be done, and they're just, it's not being enforced.
I'd like to ask a quick question, Mr. Hermanson, about Henry Nichols. I know you're not directly involved in the campaign, but he's the billionaire founder of a semiconductor company who started Marsy's law. It was his campaign. It's been his mission for life. And he spent a lot of money in a lot of states trying to get this passed, including, I assume, in Oklahoma, but I don't know the numbers. So, but he has somewhat of a checkered background, and in fact, in early August, was arrested in Las Vegas for allegedly trafficking in heroin, meth, and other things. So, should we be concerned about this Marsy's law, or whether there's any hypocrisy involved here? Or is a billionaire buying this ballot initiative for us?
Well, first of all, his daughter died, and that's what not empowered him, but caused him to go on this quest
I think it was
to have
his sister, right?
I think it was a sister.
Sister,
yeah.
I'm sorry. That's who Marsy is, and that's what caused him to be so interested in this. The fact that he may have some skeletons in his closet, the fact that he may be being charged with a crime right now, I don't think affects the language. It doesn't affect what it will do for the victims of crime. He may not be a role model we may want to pattern our life after, but I would suggest that he is not. I've never met the man. I've never talked to the man. I don't care about the man. I care about what Marsy's law will do for victims of crime.
Other questions? Question here.
Hi, thank you both for speaking today. I was wondering if either of you had any concerns about possible prejudicial impacts of victims being present in different court hearings, and whether either of you were concerned about it bolstering the ability of certain prosecutors to use victims as pawns to get harsher sentences without actually listening to what victims want.
Yeah, I mean, I would agree with those statements. I think there's something kind of in the reverse. There are some victims who don't want to have a prosecution. I mean, that seems kind of strange, but there may be someone, you talked about a theft crime, someone who had $500 stolen, and they're like, I don't want to pursue this, I don't want to mess with it, but the state pursues it. They're not listening to a victim then either. So, I mean, it can go both ways. I mean, obviously, most of what we're talking about now is the violent crimes and other crimes where the victims do want to speak. But that's kind of what I was saying earlier. I believe that there can be some prejudicial impact from a victim or victim's family member.
You confuse whether or not he's listening and whether or not he's doing what he believes his job to be. Just because a victim comes to me and expresses they don't want to pursue the case doesn't mean the case shouldn't be pursued. I've had victims that come in that feel guilty about what happened, even though they shouldn't be guilty. Domestic violence is a classic area where women are abused and go back to the person that perpetrated on them. The fact that they don't want to pursue that crime, or anyone doesn't want to pursue a crime, doesn't change. I will listen to them. I will take into consideration what they have to say. But if the crime was committed and I can prove it and I believe it should be pursued, I'm going to do that. The fact that they're in the courtroom should not in any way affect a person or prejudice a person. They're not allowed to stand up and yell things. They're not allowed to wear a button bigger than a certain size. They're not allowed to wear T-shirts that say things. They're very restricted on what they can do in the courtroom, and rightfully so. But they have a right to be there. And the fact that a person sitting in the courtroom is sitting there listening to what's going on, I don't see how that can prejudice them. They probably won't even know who they are until somewhere down the road. But I would suggest that what is wrong with someone who has been violently treated by someone being there to hear the evidence that's put on? I just don't see it.
I'm not disputing that a victim, I mean, I don't want someone to think that that's my position, that victims or victims' family members should not be in the courtroom. But I think there's a very good example that's just been, the Supreme Court ruled on it about a year ago under Bossy. It's a death penalty case. But victim impact statements, you are allowed to, as a victim, if you fit in that category, to read your statement or have it read. But there were victims who were saying they were giving the opinion of what the defendant should get, what kind of sentence that person should get. And in that particular case, the victims were asking for death, and that's what they were asking the jury to give. That has been found to be unconstitutional. I mean, that is not allowed. So I think there is a fear that victim family members can go on and give their opinion, and it may not always be legal or right.
But usually those victim impact statements are rewritten. Usually they're seen by both sides before they're read. The court reviews it. There's a hearing to determine whether or not there's anything that would be overly prejudicial to the party. It shouldn't be a problem.
But that's what happened in this case, and it had to go up to the Supreme Court to be told that that's not allowed.
And now it's the law. So
right.
We have a question here, second row. On the end, yeah.
Ma'am, I would like to ask you if the perpetrators, you keep saying that the victims have the statutes already in place, but isn't it true that the perpetrators also have statutes in place as well as constitutional rights? And can you tell me why, as a mother of a 14-year-old that was murdered, I should not have equal rights to him?
First of all, I'm very sorry. Sorry for my voice. I'm very sorry for your loss. I mean, I don't want it, again, to look like I have no empathy for victims' family members. I mean, when you have a crime, especially homicide, everyone is hurt. I mean, there's some kind of pain everywhere. But I can only speak from what the Constitution allows, and the Constitution provides rights for defendants. Now, I know that that's what I'm talking about the U.S. Constitution. There's not a lot I can say to say that a victim's family member should not have the same rights, but I just legally don't think that's true, and I can't give you any kind of backing for that. I mean, that's just the way the Constitution, it is there to make sure that people are prosecuted properly and that the innocent don't get imprisoned and that the guilty go free. I don't know really what else to say to that.
Thank you. There's a question over here.
I'm sure you're aware juvenile court operates really differently than adult court. And you keep talking about the impact statement and victims getting to sit there. Juvenile court, when you're the victim, you don't get to give your impact statement, and you don't get to sit in that court. I had a 10-year-old who testified against her rapist without her parents there. Will Marsy's law affect that? Because that really needs to change. When you're the victim in juvenile court, you sit in the dark.
It does apply to juvenile proceedings.
It does.
Correct. So
I'm confused. Are you saying that the defendant is a juvenile or that there was a juvenile involved?
The defendant was a juvenile and the victim was a juvenile.
I think that it does.
Those are
affect
confidential
juvenile
courts, and
proceedings.
that's why they're kept out. This would allow
Exactly.
you to be present by the Constitution.
any other questions? As someone who hasn't asked a question. Okay.
Back of the
I
room.
think at the back.
Way in the back.
Oh. Oh, in the very back. Okay. Be sure and speak up into the microphone.
I just wanted to make a clarifying point when we were talking about the difference that this may have on criminal justice reform. Really, that has to do with what the laws and the sentencing are set by the law, and that's a lot of criminal justice is trying to change that sentencing because many of them, research is showing, is too long and really does not have a powerful impact, the positive impact we're looking for. This may impact if you have the right to be able to know that as a victim. And I will say our family was a victim of crime. Our agency serves victims of crime, so my heart is with victims. But I was also able to be part of the criminal justice reform, and the two really work hand in hand together. But it does be able to say, yes, there are statutes. Our family didn't know we could fight a plea bargain. We didn't know we could have an attorney that could also represent us as the victims. There are many things that victims do not know and are not told that are, you're right, they are rights currently in statute, but there is, it's just that. If
Okay.
there's any conflict, it is still, they're not told.
Thank
Whereas
you.
perpetrators' rights are in constitutional law, and this is really just trying to bring them to equal grounds.
I can tell you that if Marsy law is passed, I think they're already working on a videotape to train prosecutors and their support staff on how to comply with Marsy's law and how to make those changes that are necessary to be made. So their training is already in place if it passes. In fact, that training will happen a few days after the election. It's good.
Well, we'll conclude this forum with just final statements. I guess I'd ask each of you to spend just 1 minute perhaps telling us what your greatest hope or your greatest concern is if Marsy law passes.
Oh.
Go
Okay,
ahead.
sorry.
Legler.
You know, I just, I think the greatest hope is that if it does pass, is that we don't see a slowdown in the judicial system like we fear, and that we don't see costs that other states are experiencing. I mean, we're already a state that's in a budget crisis, and I would hate to see that this adds to that.
Mr.
My greatest
Hermanson.
hope is that the victims will be confident in knowing their rights and being able to come into the courtroom, being able to know what they can do and meet with their prosecutors and talk about them. I don't have a lot of concerns. I don't think it's going to slow down the system. I don't think it's going to cost a lot more money. I think it may cause the system to go forward. In civil cases, many times a party has to go to has to tell their party about a continuance that's going to happen so that they are aware there's going to be a delay. It'd be nice if you all knew that the case is going to be continued, a motion was filed or requested as to happen for continuance before it happens so that you can indeed be in the room and have some input into that. It'd be nice for you to have those rights that in civil law they do have. I just think it'd be a good thing overall.
Please give our guests a round of applause. Thank them for participating.